appeal in the matter of Prismall and Google UK Ltd holders.
Yes.
May it please the Court, my name is Mr. Pitt Payne, and together with Mr. Stephen Cosmin of Council, I appear for Mr. Andrew Prismall. Mr. Prismall is the appellant in this case. He is the representative claimant in the proceedings to which this appeal relates. My learned friend Mr. Anthony White, KC, leading Mr. Edward Craven, appears for the respondents. They are the defendants in the relevant proceedings. There are two defendants, firstly Google UK Ltd, secondly DeepMind Technologies Ltd. There's no material difference between their position for present purposes. No point is taken on the other side about any difference between their position. So I shall refer to them together simply as Google. I hope the Court have the following, either electronically or in hard copy. Firstly, a core bundle running to 10 tabs, 141 pages. Secondly, a supplementary bundle running to 24 tabs, 329 pages. And thirdly, an authorities bundle, the hard copy of which runs to 3 volumes and 40 tabs. Can I ask whether any members of the Court are using the electronic version of the authorities bundle?
I am.
I'm grateful. There may be a small discrepancy
There always is.
as to pagination.
I wouldn't worry about it.
I understand that it only kicks in pretty much at the very end of the bundle,
Right.
and I shall do my very best to navigate around that. May I check one other point? Last week the Court asked for skeletons in Word form. I hope that those have reached.
They have. Thank you very much.
Thank you. We have one day for this appeal. Mr. White and I have discussed timings. Subject to the Court, I'm aiming to finish by the short adjournment, and he will aim to finish in time to give me about half an hour in reply this afternoon.
Sounds about right.
I'm grateful. So what I would like to do is to begin by setting the scene with some points about the claim and the circumstances that have led to it, before then turning to the judgment and the grounds of appeal. So, first of all, the claim. As the Court will have seen, this is a claim for misuse of private information, or MOPI for short. It's brought by Mr. Prismall, and he brings it as a representative claimant under what is now CPR 19.8, on behalf of a very large class of individuals. The class is thought to be at least 1.6 million individuals. We take that number from some correspondence from the Information Commissioner's Office, though for reasons I'll come to, we think it's likely that that is an understatement. We say that the size of the class in itself reflects the very significant impact of the matters to which this claim relates. The claim relates to the transfer of medical records of identifiable patients on what we say is an industrial scale from an NHS trust, which I'll refer to as the Royal Free, to Google. This transfer occurred without the knowledge or consent of any of the individuals concerned, any of the individual patients whose records were transferred. There was no attempt to anonymise the records in any way prior to transfer. The claim is brought against Google. There's no claim against the NHS body, the Royal Free NHS Foundation Trust, to give it its full name, or any of its predecessors. The represented class, as formulated before the judge below, is set out in the judgment, and I'll come to it in due course. The Court will have seen annexed to our skeleton argument a proposed amended class definition if we need to rely on it. That specifically relates to ground 3 of our grounds of appeal, which is that if, contrary to my primary submissions, the judge was right that the claim as pleaded was not viable, we should have had the opportunity to amend to meet the judge's concerns rather than the claim being struck out and not being able to go forward at all. So the basis of this claim for MOPI is that each member of the represented class had a reasonable expectation of privacy in relation to that individual's medical records that were transferred to Google. And we say that Google's collection, receipt, storage, holding, and use of those medical records amounted to the tort of misuse of private information. And we say that each member of the class would be entitled to damages for the loss of control of their private information. As far as the question of whether loss of control damages are available in the tort of MOPI, we say that that is well established now. It was established by this court in the Galati case. It was recognised by the Supreme Court in Lloyd versus Google. And we say that that label of loss of control is a very apt description of the nature of the wrong of which we complain in this case. Because we say that the result of medical records being transferred to Google, not only without consent, but without even there being notice of the transfer, the result of that was that it deprived patients of any opportunity to withhold their consent or any opportunity to object to the transfer. Now, it's said against us that this is not viable as a claim on a representative basis because damages would require to be individually assessed. To meet that, what we do is we seek damages calculated on what was described in the Supreme Court in Lloyd and Google as a lowest common denominator basis. So we say that there is a minimum level of harm suffered by every member of the represented class, and we say that that minimum level of harm gives rise to an entitlement to damages to every member of the class. And we say that on that basis, it's a claim that can properly be pursued as a representative claim under CPR 19.8. It's a claim in relation to which every member of the class would have the same interest for the purposes of CPR 19.8, and hence a representative claim is appropriate. Now, the claim was struck out by the judge on the basis that there was no reasonable prospect of establishing, first, that all class members had a reasonable expectation of privacy, second, that all class members had suffered actionable interference with privacy, and thirdly, that all class members would be entitled to damages over and above nominal damages on a lowest common denominator basis. When it comes to the judgment, the main focus of the judgment was on the question of whether all class members had a reasonable expectation of privacy, because the judge answered that question in the negative against the claimant, what the judge then finds in relation to actionable interference and entitlement to damages very much follows from the judge's findings in relation to reasonable expectation of privacy. So the focus of my submissions, as with the judgment, the focus of my submissions is going to be on the question of what the judge found about a reasonable expectation of privacy. We appeal with permission granted by Lord Justice Warby on the papers on the 6th of December 2023. We say that the appeal raises a number of highly significant issues, as was recognised by Lord Justice Warby when he gave permission, but we say they're not being approached in the abstract. All of these issues must be seen in the context of a strikeout scenario, we say, where the overriding impetus should be to allow the claim to proceed to trial with full evidence, if that's at all possible. So the key consideration in approaching all of these matters is whether the draconian step of striking out the claim should have been taken, or whether the claim instead should have been allowed to proceed. The issues raised, I want to flag 4 issues which are recurring themes in this appeal. Firstly, the permissible uses of patient data as contained in medical records. Secondly, the circumstances in which such data can permissibly be shared by health providers with commercial companies. Thirdly, the boundaries of what is called direct care, and we say that this is highly relevant when considering patient expectations as to the use of their data. It therefore feeds directly into the question of reasonable expectations as to privacy. And then finally, the availability of representative claims arising out of such matters as the collection, receipt, storage, use of medical records, in the light of the Supreme Court judgment in Lloyd versus Google. So that's the claim and something about the issues. I'd like to turn now to some points about the circumstances giving rise to the claim, because these points these are the foundation for the grounds of appeal. So the data transfer that gave rise to this claim took place from October 2015 onwards. It was a data transfer from the Royal Free to Google. It consisted of 2 things. Firstly, a very large initial transfer of data in October 2015, followed by a continuing data feed. Now, as I've already indicated, there isn't a precise figure for the number of individuals whose information was transferred. The ICO's figure of 1.6 million, which I've already mentioned, is likely to be an underestimate given the information which was provided by Google in support of their strikeout application, because their evidence made it clear that the transferred data includes not only data about people who attended at hospital, but information about blood tests that were ordered by GPs and carried out in the hospital laboratories. And it's not at all clear that that is a matter that the ICO took into account when giving their estimate.
Is that material in any way, the number of claimants, to the issues raised? If one takes 1.6 as a figure, does it make any difference whether it's rather more or rather less?
It's material when it comes to consider the exercise of discretion as to whether there should have been an opportunity to amend if necessary. Because one of the matters there is the range of individuals affected by the claim, the potential scale of the claim. On the question of whether the lowest common denominator individual has a viable claim or not, the size of the class is not directly relevant, I accept that. So, looking at the records that were transferred, the Royal Free, that encompasses 3 hospital estates, the Royal Free Hospital, Chase Farm and Barnet. Its laboratories process clinical tests, including blood tests for local GP services. The transferred information came from all hospital estates, all 3 hospital estates. It included the results of GP blood tests. And as to the information that was transferred, we have some evidence about that from 2 statements from Mr. Hughes on behalf of Google. So, Mr. Hughes says that the vast majority of the information that was transferred was set out in a standard format known as HL7. So that's a standard format for electronic medical records, and the reference is to Health Level 7 international standards for exchanging patient-identifiable electronic care records. So Mr. Hughes says in his first statement that the vast majority of the transferred information consisted of these HL7 messages. And an HL7 message would be generated every time an event took place during a patient's visit to a hospital, and that event was recorded electronically. If I can take you in the supplementary bundle to one passage in Mr. Hughes' first statement. So I'm in the supplementary bundle at page 42 of the bundle behind tab 2. So this is a standard format, and Mr. Hughes gives an example of an HL7 message. This is not a message made up of real patient data. This is what he calls synthetic data, i.e. it's a fictitious patient. And he describes the various paragraphs that are components of the message. At paragraph 2, towards the bottom of page 42. So MSH at the top of that example message is the message header. It indicates the type of message, in this case observation result. And then the next paragraph in the message is PID. That's the patient identification segment, and that gives name, date of birth, sex, address. And then, importantly for my purposes, because this is relevant to ground 3, PVI is the patient visit segment. That includes information such as the bed the patient is in and the name of the doctor. So in other words, that's the section that would record clinical contact between the individual and a clinician.
It would record the clinical contact, but not the nature of what took place between them necessarily.
Not necessarily. No, there may be OBX is the final paragraph, and that is free text observation about the patient. But what PV1 would say is there'd been clinical contact, the name of the clinician, the level of the clinician. So there, for instance, Dr. A, consultant. And if the patient is an inpatient, it tells you the bed that the patient is in.
Can you just, when you get PVI, the second line down, you've got the seems to be date of birth again, and then something visited. What's that showing?
As I understand it, that would be telling you that the patient had been visited by the named doctor.
Right, thank you. And OBR just below inpatient.
OBR, now, I'm not sure what one takes from OBR. I was looking back to see if that is something that Mr. Hughes deals with. He deals with various of the codes earlier in the statement at page 29 of the bundle. I don't think he deals specifically with OBR. May I? My junior hands up a note. We think OBR stands for observation request.
Thank you.
But if one goes on then to OBX, which you describe as the free text, that really identifies what might be described as physical steps taken. What is not included are any observations of the clinician or any conclusions of the clinician. So when it says it provides a medical record, it's a mechanical record rather than one which includes observations and conclusions of the clinician.
Well, OBX is described by Mr. Hughes as a free text observation about the patient. So it wouldn't be right to describe OBX as being merely a mechanical.
Well, it does refer, doesn't it? If you look at the document you referred us to the adenosine infused over 4 minutes, so it's an actual treatment that's been performed.
Yes. Yes.
Perfusion imaging performed during the last minute and so on. So it is describing a treatment given.
Yes. So it's describing steps that have been taken. So, as well as the HL7 messages, Mr. Hughes refers to 2 other types of data that were transferred from the Royal Free to Google, and one gets these at page 30 within the supplementary bundle earlier in his statement. At the top of that page, there's what he refers to as hospital episode statistics data. Despite the name, this wasn't statistical information. It was information about actual individual patients. It was produced following a review of clinicians' hard copy notes, and it consisted of a numerical patient identifier together with diagnostic and procedural codes, i.e. codes that would tell you what the patient's condition was and what treatment they had. And finally, there was renal system reporting data, which was an updated list of patients undergoing kidney dialysis. Now, according to Google, according to the evidence in Mr. Hughes' statement, what was transferred in that large transfer in October 2015 consisted of around 4 years' worth of data from the Royal Free and about a year's worth of data from Chase Farm. In the case of Chase Farm, but not in the case of the Royal Free, the data was mainly laboratory data. He doesn't specifically mention Barnet, the third site, but we assume that the position would be the same similar as to Barnet as to Chase Farm. In addition, there was the continuing data feed. Now, in terms of patients' knowledge, I've already made the point that patients were not asked to agree to this or informed about it. They were not informed on an individual level. The transfer wasn't advertised or put into the public domain, either by the Royal Free or by Google. I point out, and I don't need to take you to this in any detail, but there is a statutory mechanism dealing with the transfer of confidential medical information without consent. It's under Section 251 of the NHS Act 2006 and regulations made under that Act. We've got that section in the authorities bundle, but I don't think I need to turn it up. The short point is that that mechanism, that specific statutory mechanism, transferring confidential medical information without consent, was not used here. Mr. Hughes makes the point that some of the data wouldn't have related to identifiable patients. He gives the example of somebody who turned up in A&E but was not able to give a name. Now, to the extent that that is the case, it's not relevant to the claim or the appeal, because the claimant class specifically relates to patient-identifiable data. So if there was any data in there that wasn't patient-identifiable, it would fall outside the claimant class in any event, and there's no need to concern oneself with that. As to why the data was transferred, well, the position here remains somewhat murky, and that in itself, as I'll come on to, is a relevant consideration in deciding whether a strikeout was appropriate. Google says that the transfer was for the purpose of developing and deploying Streams, which is a healthcare app related to acute kidney injury, or AKI. There's no evidence that anything was done to limit the transfer to those data that were concerned specifically with kidney injury or conditions. On the contrary, at the time of the large transfer in October 2015, it's apparent that a much wider collaboration between Royal Free and Google was envisaged than solely in relation to the Streams kidney injury app. And there are 3 documents that show that, and I'd like to take you to those documents now, if I may. So the first of those 3 documents is an information sharing agreement, which you find in the supplementary bundle at tab 9, page 203. The date of that document, we get that date at page 210. It's signed on behalf of Google on the 29th of September 2015, so shortly before the large data transfer that took place in October 2015. And going back to page 203, the parties to the agreement are described as the Royal Free, Party A, and Google UK Ltd, Party B. The purpose is in section 1, at the top of page 203. It describes the minimum arrangements for regularly or routinely sharing patient-identifiable information with non-NHS bodies. It refers to the sharing being for the direct care of the patient. We say, in fact, that what's envisaged in this document goes well beyond that. At point 5 in the document, at the bottom of page 204, you have details of the agreement, the purposes for sharing the agreement, and that goes on to, there's a box at the top of page 205, why is the information being shared? That refers to something called patient rescue, which is described as a proof of concept technology platform that enables analytics as a service for NHS hospital trusts, and which has been developed by DeepMind, a group within Google UK Ltd. And then looking at the next paragraph within that box, analyses are performed on live and batch data streams. Outputs include tools to enhance adherence to and implementation of NHS NICE guidelines. This will consist of patient safety alerts for AKI and real-time clinical analytics, etc., across a range of diagnoses and organ systems. So what is envisaged here is that the data is being transferred in the context of an intention to develop a range of different clinical tools, not simply relating to AKI. There's a summary of the information to be shared. Mr. Hughes's evidence explains that corresponds with his description of the evidence of the data that was being shared. So that's the information sharing agreement.
What does Mr. or Dr. Hughes, what does he say about the that part of the agreement, if anything?
Well, let me take you to. May I take you to what he says? It's behind tab 5. And if I can pick it up at paragraph 9, page 71 in the bundle. So he sets out the passage that I've just taken you to at the top of page 71. Then paragraph 10a, he refers to the first point, the AKI detection. And then paragraph 10b, page 71, he refers to the use of other technologies, and he draws a distinction between the operation of any such technologies and the use of anonymised patient data for research and development relating to any such technologies. And he says that point 2 relates solely to the use of patient data in the live running of any such technologies once developed. Now, the point I make is that it is very difficult to reconcile that with the actual language of the ISA that I've just shown you, because the passage that I've just shown you and that he quotes at paragraph 9 talks about the output of the information sharing as being tools for various purposes. In other words, that language in my submission indicates that the purpose of this sharing is to develop things, to develop tools, not simply to use information in the context of tools if they are developed at some point in the future. So what we say is that what Mr. Hughes is adopting here is a strained reading of the agreement based on his own understanding of what would or might have happened, but looking at the face of the agreement itself, it is envisaging very wide purposes for the sharing of the information, going beyond the question of the streams app and the detection of AKI. In other words, it makes it clear that the data transfer is taking place in the context of what is envisaged as a much wider collaboration between the parties. Can I turn next to the second of the three documents which casts light on the relationship between the parties at this point? And this is behind tab 10. This is a memorandum of understanding dated the 28th of January 2016. So it's tab 10 in the supplementary bundle, page 211. One sees at the top of that page, it's dated the 28th of January 2016. It's made between DeepMind and the Royal Free. It sets out in paragraph 1 what the parties are. In paragraph 3, it gives the background and it makes it clear that there is an intention to explore projects going beyond the AKI project. That's at 3.2 and 3.4 in particular. At section 5.1, page 213, it sets out a wide range of potential future areas of collaboration that the parties may wish to explore. And at paragraph 7, it explains 7.3 that DeepMind wishes to position the trust as an anchor partner. Now, that term isn't defined or explained, except in general terms over the page at page 215. This means that the Royal Free will be a key development site for future projects. So this is shortly after the large data transfer in October 2015. But again, it's making clear that the context for that transfer is an intended wide-ranging collaboration between the parties. Then the final document in this sequence is behind tab 15 in the supplementary bundle, and it relates to an application for ethical review by Google DeepMind that was considered by an NHS Research Ethics Committee on the 10th of November 2015. And
could you give me a page number?
yes, it's behind tab 15 and it's at page 233.
233, the committee minutes.
Yes, so page 233, one has the committee minutes for the Research Ethics Committee that considered this application. And the summary of the application is at 233 going on to 234. It refers to AKI, but it goes on to refer to problems with the national algorithm that is used for spotting cases of AKI. Now, the significance of this is that the Streams app was put in place in order to implement the national algorithm. But what Google is saying here is that they are proposing to go beyond that and to create a system that works better, in effect by seeking to generate a better algorithm. They say at the bottom of 233 the problem is with the algorithm itself. We think we can overcome these problems and create a system which works better. Over the page at 234 they explain how they propose to do that. So what one has is a transfer of data in the context of what is envisaged at that time as being a much wider collaboration than simply in relation to the development of the Streams app for AKI. Now, as we understand it, Google was not paid for any of this work that it did for Royal Free. We say that this reflects Google's long-term and wide-ranging ambitions for this collaboration, and indeed in relation to the healthcare sector more generally, as evidenced by the 3 documents I've shown you. So, what happens after the transfer? The transferred medical records information is held by Google. It's used for the development of the Streams app. The data held by Google is what's called normalized. It's put into a format that enables it to be used in conjunction with the app. We say that that normalization process is itself part of the development of the app. There is clinical safety and effectiveness training of the testing of the app between about December 2015 and December 2016. Google accepts that this involved some use of real patients' data. They say only about 200 to 300 patients. The Streams app was registered with the Medicines and Healthcare Products Regulatory Agency on about the 30th of August 2016. So some time after the initial transfer has taken place, and it moves to live deployment at the hospital from February 2017. Now, the Information Commissioner's Office becomes involved in scrutinising the transfer and use of the data in 2016 and 2017. And we say that the views of the ICO are important, in particular because their views support what we say about the expectations that patients would have in relation to the use of their data. Now, the ICO's conclusions set out in a letter of the 3rd of July 2017. If I can take you to that letter, it's in the supplementary bundle behind tab 6. So, at tab 6, page 89 in the supplementary bundle, it's a letter from the ICO to the Royal Free's chief executive saying that, that the Commissioner's concluded his investigation into the provision of patient data to DeepMind. And moving forward to page 92, at the bottom of that page, we see what the Commissioner says. My investigation has determined that under the terms of the agreement with the Royal Free, DeepMind processed approximately 1.6 million partial patient records for the purpose of clinical safety testing without those patients being informed of this processing. I wasn't satisfied that the Royal Free had properly evidenced a condition for processing that would otherwise remove the need to obtain the informed consent of the patients concerned, and our concerns in that matter remain. May I draw your attention also to what is said at page 93 under 3.1.1. The heading is Principle 1, that's referring to the data protection principles. But the Commissioner says this: the processing of patient records by DeepMind significantly differs from what data subjects might reasonably have expected to happen to their data when presenting at the Royal Free for treatment. For example, a patient presenting at accident and emergency within the last 5 years to receive treatment, or a person who engages with radiology services and who's had little or no prior engagement with the Trust, would not reasonably expect their data to be accessible to a third party for the testing of a new mobile application, however positive the aims of that application might be. And the Commissioner then goes on to consider whether this use of the data can properly be regarded as falling within the scope of direct care, and on that basis can be regarded as having the implied consent of the patient. The Commissioner says towards the bottom of page 93, halfway through the last substantial paragraph, that he's considered the advice supplied by the National Data Guardian and concludes that the Royal Free did not have a valid basis satisfying the common law duty of confidence. In other words, the Commissioner's conclusion, informed by the National Data Guardian, is that this use does not constitute use for the purposes of direct care. Google issued a penitent press release, the terms of which are set out in the judgment at paragraph 57. So that's in the core bundle behind tab 7 at page 92. This is Google's press release set out at paragraph 97. They say that in their determination to achieve quick impact, they underestimated the complexity of the NHS and the rules around patient data. At the bottom of the paragraph, we got that wrong and we need to do better. And then Google's evidence is that the provision of streams to the Royal Free came to an end by the 31st of January 2023. So those are the circumstances. Turning then to the way that the class is defined, can I take you within the core bundle to tab 3, so within the core bundle to tab 3, behind tab 3 at page 45, so tab 3 is our skeleton for this hearing. Page 45 is an appendix which sets out the class definition, both in the form that it was before the judge. Now, the underlined text is a proposed amendment, so that relates to our ground 3. If, contrary to our primary submissions, the class as defined gives rise to the difficulties identified by the judge, then we say that those difficulties could be avoided by the terms of the amendment that appears in the underlined wording. I'll come to that wording in more detail later on. Now, the point I make at this stage is that the class is defined in 3 groups. Firstly, point 1, those who presented for treatment at any hospital, clinic or other medical service provider between specified dates. Secondly, those who are included in the radiology electronic patient record system as at a particular date. Thirdly, those who were included in the data relating to blood tests on blood samples from GP clinics stored by the Royal Free between particular dates. So those 3 groups, 1 presenting for treatment, 2 included in the radiology record system, 3 included in the blood test data. And in each of those 3 cases, the class covers those individuals whose patient-identifiable medical records, whether partial or complete, were included in the data collected, received, stored, held or used by the defendants, or either of them, from the 29th of September 2015 onwards. And the point I make is that the judge's concerns in relation to the viability of the class and whether every member of the class would have a reasonable expectation of privacy relate solely to point 1, those who presented for treatment. If one looks, and I'll come to it, at the judge's formulation of the lowest common denominator claimant, against which the judge tests the viability of the claim, that's at page 166 of the judgment, that's squarely focused on point 1 of those 3 points. So if there is a problem and one needs to fix it, and we would seek to fix it by amendment, that's our ground 3, the focus there would be on point 1 rather than on points 2 and 3.
Can I just ask a question on the way you formulate it? On that paragraph 1, 2 and 3 are disjunctive or can be disjunctive, is that
Yes.
right?
Yes.
So another way of fixing it would be to strike out 1 if the judge was right.
In theory, that's not what we seek to do.
I understand that.
Yes.
But I mean, you can deal with this on your ground 3, but normally if you say the judge is wrong in her conclusion, but another way of dealing with her conclusion is strike out 1, but you don't seek that.
We don't seek that, but yes, my lord is exactly right.
But you don't seek that even now.
We don't.
Thank you.
Now, turning then to the judgment and focusing on the focusing primarily on what the judge said about the reasonable expectation of privacy, the key section in the judge's reasoning, so if one turns to tab 7 in the core bundle, so the judge addresses the question of a reasonable expectation of privacy from paragraph 117 onwards, and in addressing that question, the judge formulates an irreducible minimum scenario. That's at paragraph 166 of the judgment, page 118 of the bundle. And effectively what the judge does is she proceeds on the basis of that scenario. She asks whether every member of the class would have a realistic prospect of establishing a reasonable expectation of privacy. She says, well, that depends on what the situation would be in relation to an individual who satisfied the description at paragraph 166. And there are a number of features of that description. And she says, because an individual who satisfied that description would not have a reasonable expectation of privacy, therefore, one can't say that the class as a whole would have such an expectation. Now, this is the subject of our first ground of appeal. The first ground is that the judge erred in her conclusion as to the reasonable expectation of privacy of the members of the class. So that conclusion rests on paragraph 166 and is stated at paragraph 168 of the judgment. Our first ground of appeal breaks down into 5 subgrounds. The first of those, 1A, is what the judge called the medical records submission. The key point for this submission is that all of the information transferred to Google consisted of medical records or extracts from medical records. Our case is that in the circumstances of this case, that is sufficient to establish that every member of the claimant class had a reasonable expectation of privacy. And that is wholly consistent, we say, with the position that was taken by the Information Commissioner's Office in the letter which I've just shown you. And we make 4 key points in relation to that submission. Firstly, we rely on a passage from the European Court of Human Rights in the Z and Finland case. I don't need to turn that up because the relevant passage is set out in our skeleton argument at paragraph 32. The court stated that it's crucial not only to respect the sense of privacy of a patient, but also to preserve his or her confidence in the medical profession and in the health services in general, noting that without such protection, those in need of medical assistance may be deterred from reading such information of a personal and intimate nature as may be necessary in order to receive appropriate treatment, and even from seeking such assistance, thereby endangering their own health and, in the case of transmissible diseases, that of the community. Now, the context of that was a discussion of the application of Article 8 of the European Convention on Human Rights. Article 8 is the foundation for MOPI. One sees that repeatedly in the authorities, certainly going back as far as the Naomi Campbell case. I don't think I need to turn that case up now, but the point is that MOPI has developed in order to give effect to the values underpinning Article 8, particularly in dealings between private individuals or bodies, rather than as between the individual and the state. Now, what Z emphasises is the importance of maintaining the relationship of confidence and trust between the individual and the medical profession, and respecting individuals' expectations as to how their medical records are treated is a key aspect of this. Now, I make those points because what is said against us by the defendants in relation to this first aspect of ground 1 is that they say we are conflating questions about privacy and questions about confidentiality. So they say privacy is about the quality of the information in question. Confidentiality is relational. They therefore suggest that our focus on the importance of the relationship between an individual and their doctors or health service providers and the expectations that that gives rise to, they say that that is illegitimate. What we say about that is that there is a clear overlap between MOPI and breach of confidence in this sense, that the existence of an obligation of confidence or an expectation that information will be kept confidential is one of those considerations that's relevant when assessing whether there's a reasonable expectation of privacy. And for that interaction, we say that's clearly demonstrated by the ZXC case in the Supreme Court. And I'd like to turn that up, if I may. It's in the authorities bundle behind tab 23. It's a MOPI claim against a media organisation arising out of the publication of information derived from a confidential letter of request directed by a UK law enforcement body to one of its counterparties in a foreign state. And one of the issues was whether the confidential nature of the letter was relevant when considering whether there was a reasonable expectation of privacy on behalf of the claimant. And the answer to that question was yes. Just a couple of passages to refer to make that good. Firstly, at paragraph 36 in the judgment, which I have at page 822 in the authorities bundle, which records the finding of the Court of Appeal that the judge had been entitled to place reliance on the highly confidential nature of the letter of request, i.e. the judge had not thereby wrongly conflated private information with confidential information. Secondly, paragraph 49 to 50, there is a reference to the well-known Murray factors in relation to whether there's a reasonable expectation of privacy. Factor 7, paragraph 50, the circumstances in which and purposes for which the information came into the hands of the publisher. Now that is then picked up later in the judgment at paragraph 147 onwards, where the Supreme Court accepts that as the Court of Appeal held...
Sorry, can you give me a page number for
I'm
that
sorry,
paragraph?
it's page 848 in the authorities bundle,
Yes.
para 147 onwards, dealing with the issue about the relationship between confidentiality and an expectation of privacy. Paragraph 149, the final sentence, the Supreme Court accepts that the confidentiality of the letter of request was clearly a relevant circumstance in relation to Murray Factor 7, and therefore relevant in relation to the question of whether there is a reasonable expectation of privacy.
So that's 149, is it? Yeah.
149,
Thank
yes. I'm sorry, I put the authority down, but my friend asks if I would read 150. 150, the recognition that the causes of action for misuse of private information and for breach of confidence are distinct means that there is no necessary overlap between them. Information may be private but not confidential, or confidential but not private. To prove that information is private, it is not necessary to show that it's confidential. Often, however, confidentiality and privacy will overlap, and confidentiality may well be relevant to whether there's a reasonable expectation. In particular, if information is confidential, that's likely to support the reasonableness of an expectation of privacy. So the final sentence of paragraph 150 is to the same effect as the passage to which I took you. Now, before the judge, there was a considerable volume of material about NHS policy and GMC requirements of professional conduct with regard to medical records. And I want to take you briefly to some of that material. We say that all this material informs the reasonable expectations of patients. It demonstrates a high expectation of privacy in relation to information held by the NHS and doctors, and in particular in relation to medical records. And we say that that expectation applies across the whole of the claimant class in this case. Now, the relevant material is at, if I can pick it up behind tab 34 in the authorities bundle. I'll take this as shortly as I can, I bear in mind the time. So behind tab 34, the Caldecott Committee...
Sorry, if you give me a page number.
I'm sorry.
It's all right. Page
999 in the authorities bundle, behind tab 34. It may be that you need page 1001 in
I've got it.
PDF. I'm very grateful. So, the Caldecott Committee, extremely well known as really the starting point of consideration about the way that patient data was to be handled. The 6 Caldecott principles set out at page 1000, without going through them in detail. They show a very considerable concern for the privacy and confidentiality of any patient-identifiable information. Turning then to the Information Governance Review in 2013, sometimes known as Caldecott 2. So this was a second commission under the same chair, and that deals in particular, the points that I'm referring to, with the question of implied consent. So page 1103 discusses implied consent, and the proposition there is that where information is used for direct care, there is implied consent for the sharing of that information, but not otherwise. At the bottom of page 1104, implied consent is applicable only within the context of direct care of individuals. That's under the heading implied consent. And at page 1105, one has a definition of direct care. Put shortly, there would be a distinction between the direct care of an individual and for example, medical research or the research and development of a new clinical device. And as one would expect, those expectations in relation to how patient data is handled within the NHS are also reflected in documents from the General Medical Council, the GMC, about the professional duties of doctors. Can I look at two documents there? First of all, behind tab 36 in the authorities bundle, page 1005 in my page count. It may be a couple of pages further on for those working electronically. So this is guidance from the GMC that was in force between the 12th of October 2009 and the 25th of April 2017. Looking within that guidance, can I invite the court to read paragraphs 25 to 29 and then over the page at paragraph 33? And then, if the court's had an opportunity to read that, can I then take you to the final document in this sequence that I want to refer to, which is the GMC document in effect from the 25th of April 2017, behind tab 39, documents entitled Confidentiality, Good Practice in Handling Patient Information. And again, if I can invite the court just to read paragraphs 9 to 12 and 26 to 29 of this document. Those are the sidelined passages in this document.
Sorry, the page number again. Just give me your page number.
My page is 1113 for para 9 and 1118 for para 26.
Yes.
Now, we say that all of this material, the approach taken in this material, is reflected in the position taken by the ICO in the letter to which I've previously shown you, both as to what patients would expect and as to the scope of direct care. None of this material recognises a category of anodyne material medical records that can be shared with impunity by any NHS body or by clinicians. In relation to this material, there are two things that are set against us. One is that we are conflating confidentiality and privacy, and that the material that we rely on is relevant to confidentiality but not to privacy. As to that point, we rely on what I've already said about the relationship between these two concepts. It's also said against us that these materials are about matters of policy or professional conduct, that they're not directed to potential civil liability at all. What we say to that is that that does not in any way prevent them from being relevant to whether there's a reasonable expectation of privacy. These documents feed into patient expectations about how their medical records will be treated. And crucially, the relevant expectations would apply across the entirety of the class in this case, because by definition, the class is concerned with those whose patient-identifiable medical records were transferred. In particular, it would apply in relation to the specific types of information that were transferred. In particular, it would apply in relation to the HL7 messages, which were, as you've seen, the great bulk of the transferred information. Now, thirdly, we rely on the practical realities of the relationship within which this case, with which this case is concerned. So, if one takes the case of an individual patient, for instance, who attends at A&E, if one considers, for instance, the information that could be recorded about that individual by the hospital receptionist, the individual doesn't know, and they wouldn't expect to know, how much of what they told the receptionist would be recorded and would form part of their medical records. Their reasonable expectation of privacy, we submit, would be an expectation of privacy in what is recorded and written down, whatever it might be. And going on to the fourth point, which is related, it's important, we say, to bear in mind the relationship between that reasonable individual and their medical records. There's a considerable disparity of power and knowledge between the individual patient and the body that holds their medical records. The individual won't know the form in which their records are held. Still less will they know what's actually contained in the records. If one takes the specific case of HL7 messages, which I took you to earlier, even for the patient, and it would be a rare patient, who has some idea of the existence and nature of an HL7 message, the actual content of that message will be opaque. It'll be a black box, if you like. The patient's reasonable expectation, we say, would be that their HL7 messages, generated by events taking place in the healthcare context, wouldn't be shared, whatever they might contain. Now, the judge rejected our approach to medical records and the significance of medical records. She dealt with that at paragraph 133 of her judgment. Can I take you to that paragraph? It's in the core bundle at page 110, behind tab 7. So, the first 2 points that the judge makes at paragraph 133 can be considered together. What the judge is saying here is that there's a threshold of seriousness under Article 8, and hence in determining whether there's a reasonable expectation of privacy. And the judge says that our approach to medical records doesn't have sufficient regard to the threshold of seriousness and the need for an evaluation of all the circumstances. But we say there's nothing inconsistent in saying, yes, there is a threshold of seriousness, but in the present case, where all of the claimant class have had their medical records transferred, all of them are subject to those expectations derived from NHS policy and professional standards. So all of them will pass that threshold. And indeed, if you approach the case as the judge did, by constructing a lowest common denominator case, which is what the judge did at para 166, and then asking if there's a reasonable expectation of privacy in that case, then you are indeed looking at matters in a case-specific way. We don't complain of the methodology of constructing a lowest common denominator case. What we complain of is that we say on a proper approach, there is a reasonable expectation of privacy in that case, and hence in all of the other cases also. As to the judge's third point, the judge refers to unfortunate consequences if inadvertently erroneous transmission was capable of amounting to an infringement of Article 8. Well, for a start, the present case is concerned with deliberate transmission, and on the Google side, deliberate receipt, not anything inadvertent. And secondly, even as matters stand, erroneous transmission would probably involve a breach of data protection legislation, giving rise to potential possible regulatory consequences, even if it didn't give rise to individual claims. Then the judge's fourth point was that the case law suggested that a spectrum exists even in relation to information generated by the doctor-patient relationship. The judge refers there to two first instance decisions in the ZC and the Underwood case. We say that those decisions don't take matters significantly further forward. I'd like just to turn up both of those decisions briefly. First of all, the ZC case, that's in the authorities bundle behind tab 16. My pagination is 568. Now, that was a case with rather unusual facts, where a patient had chosen to bring a private prosecution arising out of circumstances to do with her attendance at an A&E department. If I can pick it up at paragraph 164, page 605, the claimant is complaining of a deliberate communication to a third party of information in relation to which she said she had a reasonable expectation of privacy. The third party in question being a GP against whom she was bringing proceedings. Paragraph 170 the judge states there that context is all important. I accept that the mere fact of having had hospital or other treatment without anything more may itself be private information. For example, if someone has attended at a clinic from which the nature of their illness can readily be inferred, but everything depends on the circumstances, I entertain doubts that the mere fact of a person's attendance at an AE department would without more constitute private information. But I need now...
Must be, I do not need
I do not, clearly I do not need to decide that in this case. and he says the claimant can't have had a reasonable expectation of privacy because she launched a private prosecution, and as part of that evidence, her attendance would have had to be made would have had to be disclosed in any event. To the same effect, para 171, she can't have had a reasonable expectation of privacy about her use of a false name, both because that would inevitably have come out in the course of the private prosecution, and also para 172, final sentence, can't be an expectation of privacy in relation to an attempt to deceive a hospital professional. So the expression of doubt at para 170 is in relation to a matter that specifically the judge states that he doesn't need to decide. Then the Underwood case...
There's another issue about it, but probably not material, but putting aside the facts of the rather peculiar case, the reasonable expectation of privacy arises not at a point when you're trying to, one would think, at a point when you're trying to litigate in relation to that information or use of it.
Yes.
It arises obviously prior to that.
Yes.
But that's a different one.
That must be right. Yes, that must be right. And likewise, on the facts of our case, we say the reasonable expectation of privacy in relation to the transfer, or looking at it from Google's point of view, the receipt, arises at the point that those take place. At the point that the information is transferred, the question is whether it's transfer or, for the purposes of this case, it's receipt by Google.
Or is it when you impart the information, or the information is recorded?
Well, the reasonable expectation applies from the point where it's imparted and recorded, but it continues and remains in effect, we say, when the information is received by Google, stored, used, etc. by Google.
Can I just ask a question on the reasonable expectation of privacy? It seems to be common ground between both of you that it's an issue of law, is that right?
Yes.
But against the particular factual circumstances of an attendance in the light of, you say, professional obligations, and
yes.
Mr. White disputes.
Yes. So, and the question for present exercise is whether the judge was right to say that there was not a realistic expectation of establishing a reasonable expectation of privacy across the class as a whole, applying the legal principles to the facts of this particular case.
Thank you.
Then the second case referred to by the judge, the Underwood case, you have that behind tab 21, and Underwood is a case where the first claimant gave birth in hospital to the second claimant. The hospital allowed a private company called Bounty, which described itself as a pregnancy and parenting support club, to have access to expectant mothers being treated at the hospital. What happened in this case is that one looks at paragraph 36, page 775, a Bounty representative had access to the first claimant in hospital, and the judge concludes that it's likely that the Bounty representative obtained the newborn's name and thereby gender from the feeding chart or from an incomplete form which the Bounty representative would have been able to see. One sees that conclusion in the first sentence of para 38, page 776. Now, if one looks at why this claim actually failed, one has that at para 52 to 53. And the key problem was that it couldn't be established that the hospital had itself misused any information. At most, what it has done is allow the bounty representative to have access to the claimants. That did not establish misuse by the hospital itself. That's para 52. Para 53, although not a point that received any real attention at the trial, even if the claimants had established that the second defendant was liable, the information so obtained was trivial, amounting only to the name, gender and date of birth of the second claimant. It's difficult to follow that in the light of paragraph 36, which suggests that all that was obtained was name and gender. Be that as it may, the key point here is that what's said at para 53 is directed to a point that didn't receive any real attention and isn't the basis on which the claim is disposed of. The claim is disposed of on the basis of para 52. So that's what I say about the judge's point 4. The judge's point 5, going back to the passage at 133 of the judgment, page 111 now in the core bundle, the judge's point 5 was that the NHS and GMC materials are not aimed at identifying the circumstances in which an affected individual would have a viable civil claim. I've already addressed that point because what we say is that that may be true, but it doesn't alter the fact that those materials are highly significant when it comes to asking what would be the reasonable expectations of patients as to how their medical records would be handled. And then finally, the judge's point 6, that's the subject of our ground 1B, so I'll come to that in due course. So, if one summarises this, if one looks at the judge's irreducible minimum scenario by reference to the Murray factors, we set out in our skeleton argument what we say about each of those factors. This is a paragraph 38 of our skeleton, page 35 in the core bundle. We say that each of those factors, with one possible exception, strongly support there being a reasonable expectation of privacy across the whole class. The attributes of the claimant, that's the first factor, they're all patients. The nature of the activity, they're seeking medical treatment or testing. The place, at a Royal Free Hospital, clinic or other place. The nature and purpose of the intrusion. The intrusion is the collection by the defendants of information that's not for the purposes of direct care. Consent, it's clearly absent, there's no basis on which it can be inferred. Now, as far as the effect on the claimant is concerned, we don't rely on any individualised impact. That's because the claim is across the class as a whole and is only in relation to the lowest common denominator harm. The circumstances and the purposes for which the information came into the hands of the defendant, I'll deal with that in more detail under ground 1C, but effectively the circumstances include not just the development of the streams application, but also the very wide-ranging proposed collaboration with Google, which is the subject of the documents that I took you to earlier on. So, within my first ground of appeal, that is 1A in relation to reasonable expectation of privacy. I turn then to 1B, the public domain issue. Now, the judge laid some emphasis, and one sees this at paragraph 166 also, on the proposition that, at any rate for some members of the class, it can be taken that they would have put into the public domain information contained in their medical records. Now, what we say about this is we say that the placing of equivalent information in the public domain by the patient doesn't to any extent affect their reasonable expectation of privacy in relation to the equivalent information when it's part of their medical records. So Google makes some play of this point. So they refer to the fact in their skeleton that Mr. Prismall himself has placed information in the public domain about his own medical condition. And they give examples of other patients who've done likewise. And we say that properly understood, none of this assists them at all, and the judge was wrong to find that it did. And in that regard, we rely on a passage which we say is extremely apposite from Caldecott 2. If I can go back to that, that's behind tab 38 in the authorities bundle. And in terms of my pagination, it's page 1104A. It's section 4.4 in Caldecott 2, headed sharing information on social media. They say this: the review panel found no evidence to suggest that people's desire to protect their personal confidential data from unauthorized disclosure is weaker among the so-called Facebook generation. Increasing use of social media has encouraged people of all ages to share online pictures and information of a personal nature that might once have been regarded as deeply private. But a decision by an individual to share some of their personal information with other people on social media does not mean that those in the health and social care system should be any less vigilant in preserving confidentiality. It would be patronising in the extreme to suggest that a more lax approach to protecting confidentiality could be taken, or that people had it coming to them for choosing to use Facebook, Twitter, LinkedIn, YouTube, and assorted online blogs. And we adopt that, and we say that that is the proper approach to adopt the question of does it matter if people choose to put their own health information into the public domain. Now, what all that reflects is that the MOPI tort is about giving effect to individual autonomy. And in the context of medical records, what that means is that individuals are to be given control in relation to disclosure of their own medical records. And in the exercise of that control, they may choose to make information public for all sorts of reasons. So they might put information on social media because they're seeking moral support in dealing with a health condition. Or they might be trying to assist in fundraising for a medical provider. Or they might be trying to fundraise for their own medical treatment. For instance, they're seeking support for an experimental treatment not available on the NHS. We say none of those circumstances have any bearing on how they would expect their healthcare providers to treat their medical records.
They could also do it in order to encourage other people to test.
They could. That would be another possible. That would be another possible scenario.
Quite current.
Yes, yes. And again, if I choose to put information about my healthcare condition, say on social media, to say, I didn't test, this is what's happened to me, please, please, please test. Now that is something that I choose to do, that's under my control. I know what has been disclosed in what circumstances to whom. And I say that doesn't in any way affect the expectations that I would have in relation to healthcare providers, which is that they would not share information without my consent unless they were doing so for the direct care purpose. Now, Google, in their skeleton, they refer to examples of information that's generally publicly available. And they say that the mere fact that it's incorporated in medical records can't then give rise to a reasonable expectation of privacy that wouldn't exist. They give the example of the patient who is a local counsellor. And they say if a patient's a local counsellor and they mention this fact to their doctor and it's then incorporated into their medical records, there can't possibly be a reasonable expectation of privacy in relation to the fact of there being a local counsellor. What we say about that is that there is a very important distinction between these two statements. Statement number 1, Joe Bloggs is a local counsellor. Statement number 2, Joe Bloggs' medical records say that he's a local counsellor. And that second statement gives rise to potential inferences that his role as a counsellor is clinically relevant in some way, e.g. perhaps because it's causing him stress. So there'd be a reasonable expectation of privacy in relation to that second statement, notwithstanding that the fact of his being a local counsellor is in itself, of course, a matter of public record.
Is your statement number 2 not missing the fact that the local counsellor is attending the hospital for treatment X?
Yes. Yeah. Yes, that is.
But that's not your statement number 2 as you've drafted it.
It's not my statement number 2 as I drafted it, but your Lordship's point is in itself a good one. That likewise is a significance. Is of significance, not just he's a local counsellor, but the local counsellor is attending a hospital for treatment, or for treatment for a particular matter. I turn then to my ground 1C, which is concerned with the notion of direct care and its significance in the context of this case. Now, the relevance of the concept of direct care should be apparent from the NHS materials referred to above. And as will be apparent from those materials, the concept of direct care is quite fundamental to the operation of the NHS. The NHS operates on the assumption that when sharing medical records, patients' medical records can be shared for the purpose of direct care without requiring express consent, i.e. there's implied consent for such sharing. Now, that regime, in relation to direct care, that is fundamental when shaping the reasonable expectation of privacy of individuals as regards their medical records. In the present case, the representative claimant relied on 4 heads of misuse. Firstly, obtaining the medical records with a contractual entitlement to use them for purposes that extended both wider than direct care and wider than the Streams project. Secondly, storing the medical records in such circumstances. Thirdly, research and development of a novel clinical tool, the Streams application, using the medical records. And fourthly, developing or proving the defendant's general capabilities by use of the medical records with a view to enhancing the defendant's future commercial prospects. Now, the judge accepted that some of the usage went beyond the scope of direct care. And if one looks in the judgment behind tab 7 in the core bundle, turning to page 113, paragraph 114 onwards, now, what the judge holds here is that some of what happened here went beyond direct care. So, first of all, at the end of para 146, this appears to be in relation to the original transfer, the October transfer, October 2015. Final sentence of 146, I consider that there's a reasonable prospect of showing that a transfer of the patient records some 16 months or so before the Act became operational, for what at the time may have included the broader purposes identified in the ISA, was not for the purposes of patient direct care. So that appears to be the October 2015 transfer. And then at 147, in relation to storage, the judge proceeds on the assumption she describes as relatively favourable to the claimant, that the period of storage that arguably fell outside the scope of direct care is in the order of up to 12 months. And that feeds into what the judge says about direct care at para 166, subparagraph 6, page 118 in this bundle. So that's part of the components of her lowest common denominator case, and that's what she says about the scope of direct care. Now, what we say is that on a proper analysis, none of the transfer, storage or usage by the defendants prior to streams coming into operation in February 2017 was for the purpose of direct care. During that period, no patients were treated by way of streams. So rather what took place was a process of developing and testing streams so that it was ready to come into operation. And we say that doesn't constitute the provision of direct care. What all of that constitutes was a form of research and development. It was the development of a new medical tool, the Streams app. And of course, one adds to that the potential for the wider uses referred to in the documents that I showed you earlier, like the information sharing agreement.
Sorry to interrupt.
Of course.
These findings of fact, I mean, are in the context of a strikeout where obviously no facts are relevant, but reverse summary judgment. So it's just effectively provisional findings for those purposes, isn't it? The irreducible minima.
Yes, but our point in relation to direct care is that the judge's findings understate the extent to which these matters go beyond direct care, and therefore, when the judge is constructing her lowest common denominator case, it's based on an understatement of one of the matters that's relevant to what that case looks like and whether there's a reasonable expectation of privacy in that case.
Thank you.
So I referred earlier on to the process of normalising the data, i.e. putting it into a form in which it was suitable for use with streams. We say that that is not part of direct care. That's a preparatory step by way of the research and development of this novel clinical tool. the judge's approach appears to be that something can form part of direct care if it's a necessary factual precondition for the delivery of direct care. So that in effect would be a but-for question, i.e. but for this step, direct care couldn't be delivered in a particular way. And we say that that stretches the concept of direct care much too broadly. In effect, what it does is it erases the distinction between direct care and research. So when it comes to the question of the use of any data for the safety testing of the app, the judge deals with that at paragraph 154, page 115. Now, I think I need to pick this up at 152. So this is the specific point about the use of medical records and the development and testing of streams. Firstly, the judge says that that use of medical records was an aspect of direct care and thus the subject of the patient's implied consent. Now, that seems to rest on the notion that if it wasn't for that testing, you wouldn't be able to use the Streams app. That's the judge's but-for point. We say that that goes too far. One could equally say that but for the use of patient data, it might be impossible to develop a new drug. It doesn't follow that everything that's done in the development of the new drug constitutes direct care. There's also the question of how wide the cohort was that was used for the purpose of safety and effectiveness training. Now, the judge says, based on Mr. Hughes's evidence, that it was about 200 to 300 patients. The ICO documentation, which I've already shown you, proceeded on the basis that the safety and effectiveness testing involved a much larger cohort. The ICO talked about 1.6 million people being involved in safety and effectiveness training. Now, effectively, what the judge did at paragraphs 156 and 157 was to prefer what Dr. Hughes said to what the ICO had said in its letter. This was a letter by a regulator who had carried out an investigation, and on the basis of that investigation was sending findings to the hospital. And what we say is that that is not a matter that the judge should have treated as being suitable for resolving the apparent discrepancy between what Mr. Hughes said and what the ICO says. That's not a matter that the judge should have treated as suitable for resolving in the context of a strikeout application. Now, that takes me then to ground 1D. So the basis for this is what the judge says at paragraph 166, 1 to 4. So, paragraph 166, the judge is setting out what she regards as is setting out the content of the lowest common denominator class. And it's clear from this that the judge considers that the lowest common denominator could include the case of an individual who attended at the Royal Free at A&E but left without being seen by a clinician. See subpara 4. And in effect, what the judge appears to be saying is that in that situation, there would be no reasonable expectation of privacy because, in effect, there would be no substantive medical content at all in the information recorded. Now, to be clear, our primary case is that there would be a reasonable expectation of privacy in all of these cases, contrary to what the judge found, i.e. there would be a reasonable expectation of privacy in the case described at para 166, little 1 to little 4. And that's in the basis of what I've already said, particularly under ground 1A and under ground 1B. Ground 1D, which I'm currently on, is an alternative submission. The judge's finding in relation to a case of this nature is tantamount to saying that there would be no substantive or meaningful medical content in the case of the person who comes to A&E and then leaves without being seen. But if that is right, then my fallback submission under ground 1D is that those individuals would in any event fall outside the claimant class, since in those cases the record wouldn't constitute a medical record, and the claimant class is specifically framed in relation to medical records, by reference to what constitutes a medical record. And if I can take you in that regard, I can take you back to our skeleton argument. So our skeleton argument is in the core bundle behind tab 3, and at 1D, para 58, for the purposes of this alternative submission, we set out what, for the purposes of this alternative submission, we say a medical record would consist of. And that's at subpoints 1 to 5 under paragraph 58. And we say that in the context of somebody who simply left without seeing a clinician, they wouldn't come within the concept of a medical record in any event. So
would the message be generated?
well,
An 8
if,
or 7 message, would that be generated?
well, if a message wasn't generated, they would fall outside.
Yes, that's what I'm asking.
There'd be nothing to, yes, if a message wasn't generated, they'd be outside the class in any event. Because what the class consists of...
Oh, I understand that, but,
Yes.
but would it, assume for the moment that they gave their name and address but left before anything else happened, or what's the scenario? Because the person left without being seen by a clinician.
Yes. If they gave their name and address without being seen by a clinician, then, as I understand it, an HL7 message would still be generated. And if that is right, then our primary case is that there would be a reasonable expectation.
Right, I follow. I just wanted to.
Yes, I'm grateful.
And your secondary case is that that's not a medical record?
Our secondary case is if one treats that as something that simply has no substantive medical content, which seems to be the judge's approach, then the answer to that is, well, in that case, that's not a medical record, and if it's not a medical record, it's outside the scope of the class in any event.
You've taken us to your paragraph 58. These are to be read disjunctively, aren't they?
Yes.
Because if you look at 58.1, you've got the fact that the patient attended a healthcare provider and/or, so just delete it from there.
Yes.
And then isn't that the judge's 1664?
Well, our limb 1 is intended to cover the case of the person who sees somebody at a healthcare provider.
Well, that's not how it reads at 1, or not how I read it at 1. Because it says and or being seen. It doesn't say and being seen. Anyway, maybe that's being too technical.
Yes, I mean the intention for the purposes of 1D is to exclude, in the alternative, the person who left without seeing a provider.
Okay, thank you.
And then finally, there's a very short point at ground 1E, and this is in relation to para 166. Where 166.11, one of the matters that the judge refers to in framing her definition of the claimant, of the lowest common denominator claimant, is that no upset or concern was caused by the data transfer and storage. The only adverse effect was the sheer fact of the loss of control over this data in the way described. Now, this is a short point. At para 87 of the judgment, the judge rightly concluded that loss of control damages does not need to involve an individualised assessment. So para 87, page 99, the judge rejects Mr. White KC's submission that loss of control damages inevitably involves an individualised assessment. However, the question remains whether the members of the claimant class as defined have a viable more than de minimis claim for loss of control damages. Now, we were not relying on any individualised assessment. We were relying on the lowest common denominator formulation. That follows from the fact that this was put forward as a representative claim. What the court appears to be doing at para 166.11 is making an inconsistent finding that whether upset or concern was caused would be relevant to that irreducible minimum scenario, and hence relevant to whether every member of the claimant class would have a viable no-be claim. In other words, it appears to be being put forward as, if you like, a point against us in the lowest common denominator scenario. The claim is solely for damages for loss of control. It's never been a claim for damages to distress.
But I'm, well, it depends how you read it, doesn't it? You could just say she's just saying the case is not one of upset or concern. It's that, so she's listing these factors and then saying what she makes of them. You're saying she's holding it against you. The only adverse effect was the sheer fact of the loss of control over data made described, which is your case.
Yes, I mean our case is based on loss of control, not on individualised assessment. But in listing that factor, which is just inherent in the way that the case is put, it does, in my submission, suggest that she is somehow treating that as something that counts against there being a reasonable expectation of privacy in the lowest common denominator case, and we say that's not a right approach. That's not a matter that should have featured at that stage of the analysis. As I say, it's a short point. So, can I then step back and look at para 166 as a whole and summarise what we say about paragraph 166 in the light of the various aspects of our ground one? So, As to points 1 to 4, which deal with the scenario of a single attendance generating an HL7 message, etc., our primary case, about 1661 to 4, is that there is a reasonable expectation of privacy in these circumstances, in the circumstances as described. Our alternative case, and that's our 1D point, our ground 1D point, is that the person who leaves without being seen is not in any event in the claimant class. As to point 5, we say that the point about information being otherwise in the public domain is not relevant for the reasons that I've given. That's our ground 1B. As to point 6, we say that the approach should be on the basis that everything prior to February 2017 falls outside the scope of direct care. As to point 7, where there's a reference to there being a financial benefit to Google, we say that the circumstances in relation to Google are wider than that, and this is the point that I made by reference to my 4th head of misuse, i.e. use by Google for its own commercial purposes. It's not just that it would be financially beneficial to Google. What you have is the transfer of information not to an NHS body, not to a clinician, not to a healthcare body, but to a technology company in the private sector. And that is not what patients would have expected as to the use of their data, as the ICO made clear in its letter. As to point 8, firstly, the normalisation process, we say, was not part of direct care. Secondly, as to clinical safety and effectiveness training, any access to information for that purpose would likewise not be for the purposes of direct care, in line with what the Information Commissioner concluded about such access. It would be for the purposes of the research and development of a novel clinical tool. But in any event, it is not safe to assume, contrary to what the ICO said in its letter, that the extent of access for safety or effectiveness training was as limited as Mr. Hughes said. And as to point 10, I accepted before the judge that where the Streams app is actually used in February 2017, or from February 2017 onwards, then actual use of the Streams app is for the purposes of direct care. So if you have a patient who comes in and the Streams app is used in relation to that particular patient, either to see whether there should be an AKI alert in relation to that patient, or in order to access the patient's medical records, those uses, I accept, would be for the purposes of direct care. What happens prior to February 2017 is not direct care. And then point 11, we say not relevant for the reasons given in ground E. And on that basis, we say that on a proper formulation of the lowest common denominator case, and on a proper application of the principles, there's a reasonable expectation of privacy, or at least, at the very least, a realistic prospect of establishing that. Now, that then takes me to ground 2, which I can deal with quite briefly, because it really follows on from ground 1. So, ground 2 relates to the subsequent stages in the judge's analysis. Firstly, paragraph 170 to 172, the judge deals with whether there is a reasonable, a realistic prospect of establishing misuse, so use contrary to the reasonable expectation of privacy. It's very clear from paragraphs 170 to 172 that that part of the judge's analysis really rests on the judge's conclusions about the reasonable expectation of privacy. And in that sense, they stand or fall together. The additional factor that the judge mentions at para 172 as being arguably relevant at this stage of the analysis is the objectives of the Streams Act and the beneficial outcomes that it achieved. Now, we say that those beneficial outcomes wouldn't in any event assist Google because they don't answer the question, why did you obtain this information without informing patients and at the very least giving them an opportunity to opt out? So in order to bring that beneficial outcome into play, Google would effectively have to show, well, the only way that we could deliver that beneficial outcome was by transferring the data without telling anybody. And we say that that is far-fetched and fanciful. And then finally, as to the loss of control damages, they're addressed at paragraph 173 to 178. And again, it's very clear that that part of the reasoning depends on the judge's conclusions about the reasonable expectation of privacy. The only qualification there is that the judge suggested at para 175 that the transfer wouldn't be reflected in the damages figure because the transfer would in any event be required before the app became operational. We don't accept that. If we are right that there was a reasonable expectation of privacy and a transfer of information that was in breach of that reasonable expectation, then we say that transfer must be relevant when one is considering what are the appropriate damages. So whether the transfer was needed to make Streams operational, we say is properly irrelevant to the question of damages. To reiterate the point I just made, it can't be said that a transfer without even telling patients was an essential step towards constructing the new clinical tool. I've taken ground 2 shortly because the simple point is that if ground 1 succeeds, then we say ground 2 must succeed also.
Can I just ask you one question on the damages point?
Yes.
Obviously, at this stage of development of the tort of misuse of private information, there's not much jurisprudence. There's some, and we've seen that. Has there been any consideration about waiving the tort and using that as an assessment of damages in misuse of private information cases? And what would you say would be the principled response if someone raised that on a strikeout or summary judgment?
That's not a matter that I'm aware of having been considered, and nor is that a matter that, as I recall it, arose before the judge below. So I'm not sure I can assist on that, that specific point.
Thank you.
Now that takes me finally to ground 3. If the proposed appeal succeeds on the other grounds, then this doesn't arise. However, if those grounds don't find favour, ground 3 is a freestanding ground of appeal. So in this case, the claim was struck out And the effect of that was to preclude any recovery for the class. Now, in theory, individuals might seek to bring new claims, but any new claims at this point would run into very significant difficulties in relation to time bar, given that more than 6 years have passed since the February 2015 transfer, October 2015 transfer, and indeed since streams came into effect in February 2017. We say that having regard to that circumstance, and having regard to the very significant number of persons affected, striking out is a draconian step, generally, but in particular in this case. Now, the judge refused to allow an opportunity to seek permission to amend. So what we were saying before the judge was the claim as it stands is viable and should be allowed to go forward and shouldn't be struck out. But if you're against us, we should have the opportunity to consider your judgment and to put forward an amendment that would cure any defect, and that should be considered before the decision is taken as to whether the claim should be struck out. Now, the judge declined to give us that opportunity for the reasons set out at paragraphs 181 to 185 of the judge's decision. We say that that was a wrong decision, and if necessary, a decision that this court can put right. We say that we should have had the opportunity to enable the court to assess by reference to submissions rather than simply of its own accord whether there was truly, quote the judge's language at para 185, a fundamental and inherent difficulty in identifying a viable claim for any class members if this claim is brought as a representative action on the basis of common circumstances. The judge's approach was effectively that the concerns raised by the judge could not have been addressed except by way of a very radical reformulation or reconstruction of the claimant class. We say that that is not right, and we say that that's not right by reference to the potential amendment that we now set out as the appendix to our skeleton argument. So, turning to that formulation, that's at page 45 in the core bundle, behind tab 3 of that bundle. To reiterate a point that I made earlier on, the difficulties identified by the court apply entirely to category 1 of the class definition. They do not apply to categories 2 and 3, and the formulation of the lowest common denominator case, para 166, is directed to numbered category 1. And what we say, in effect, is that category 1 can be confined to those individuals who did in fact receive clinical care and or treatment, and that would operate to remove the factors that led the judge to conclude that some of the information falling within the class would be anodyne in nature. And there are two limbs to that proposed amendment. One is amending the definition of the term medical records along the lines that I have already put forward in relation to ground 1D. And the second is adding a specific reference to the PV1 data field in the context of section 1 of the class at page 45. Now, the PV1 data field, the patient visit information, I showed you earlier on the HL7 message in Dr. Hughes's first statement. I showed you the specimen HL7 message, and I showed you the P1D data field, but I also showed you the PV1, the patient visit data field. That would be populated if a patient received clinical care and or treatment, and it would be populated with the name of the clinician, and if the patient was an inpatient, it would be populated with the name or with the location of the patient's bed. So the effect of that qualification is that firstly, it would confine class 1 or subclass 1 to those who actually saw a clinician. It would also confine that class to those whose health records made it clear that they had seen a clinician and identified the clinician who they had seen, and indeed identified whether they had been an inpatient or whether they had simply been seen at A&E. Because as I've said, if they were an inpatient, that field would tell you where their bed was. So there is a significantly greater medical content in the case of those for whom the PV1 data field is populated. So even if, contrary to the various submissions that I put, even if the judge was right about the reasonable expectation of privacy on the claim as originally pleaded, my submission is that the difficulty can be met by the amendment that is set out at page 45 of the appendix to our printout.
Can I just ask you a point of detail? The judge dealt with this quite fully in her judgment.
Yes.
What was the precise chronology? Did you see the draft and then say you should be given an opportunity to amend, or was this an issue that was raised at the hearing itself?
It was an issue
followed by a draft judgment.
It was an issue that was raised at the hearing itself, and we were saying that we should be given the opportunity we should be given the opportunity to consider the judge's decision.
Contingently, if she was against you.
Contingently, yes. If the judge was against us, we should be given the opportunity, having seen that decision, to put forward a proposed amendment to meet.
So you hadn't seen her judgment at the time these arguments were made?
We hadn't. And in the judgment, she made it clear, and we saw this when we received the draft judgment, that she wasn't willing to give us that opportunity. And that was a matter that had been canvassed before her. So we say we should have been given that opportunity, and I pray in aid that there is a viable amendment set out at page 45 that would meet the judge's concerns if, contrary to my primary submissions, you concluded that those concerns were well-founded. And we say that the right approach would be to permit the opportunity to amend rather than taking what I've described as the draconian step of striking the claim out altogether. Now, that takes me to the the end of my submissions, unless there's anything else on which I can assist the court.
Can I just ask, sorry to go back to this paragraph 1 point and your page 45.
Yes.
As I understand your submissions, you say the judge's findings at 166 all relate to 1,
Yes.
which leaves 2 and 3. So why was the judge's order to strike out? Normally, if you find that parts of a claim are hopeless, you strike them out and leave in the other parts. So why did the judge strike out those parts as well?
The judge doesn't specifically deal with that. But yes, the logic of... I entirely take what your lordship says. And yes, if that is right, in any event, the judge should not have struck out points 2 and 3, but should only have struck out point 1.
But I asked you about that earlier, and you said you didn't want to take that point. Is that still the position?
Well, the position is that those instructing me have taken the view that they would wish to take the claim forward on the basis of points 1, 2 and 3, not on the basis of 2 and 3 alone.
I appreciate that, but the judge ruled against you and worked
Yes.
just in that. Okay, sorry. And the final point is, if you look at 45 and 4 lines up from the bottom, you've got the and or.
Yes.
Is that the or must go if you're talking?
Yes.
Yes. So
Yes.
sorry to draft on the hoof, but just so that I understand your submission.
You're right.
Thank you very much.
My lord is right, yes. So unless there's anything else I can assist the court with at this
Thank
time.
you very much indeed, Mr. Pitney. We'll rise and sit again at 2 o'clock. Thank you very much.